This is a lecture from Open Tuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
We're going to look now at the passing of risk. So we're in a contract for the international sale of goods and the United Nations Convention on Contracts for the International Sale of Goods. And we need to consider at what point within the life of this contract and the process of sale and purchase, at what point does risk pass from the seller to the buyer? And we have here, we've got three possible situations. Well, in fact, we've probably actually got more, because what I'm going to do when I start looking at them is we're looking at specific goods down here. But we've also got the problem of unascertained goods. So just bear in mind what I'm about to say, unascertained. It's not in the notes, but bear in mind what I'm about to say, because we can apply that to contracts that do involve carriage, contracts for goods sold whilst in transit, and contracts not involving carriage. So all these three situations can apply to specific and or unascertained goods. But I only deal down here, I'm only dealing with specific goods. So let me have a quick word about unascertained goods. Unascertained goods, if they're unascertained at the start of the contract, then we shall treat them as unascertained right the way through the contract. And the rules that relate to unascertained goods are then applicable where those goods are simply in inventory, they've not been identified as being subject to or part of the contract, and that's what we're looking at. And the time of passing of ownership, which is essentially when risk passes, remember that as well, risk passes normally with ownership. The time of passing of risk with reference to unascertained goods is when the goods have been unconditionally appropriated to the contract and the buyer has notice of that fact. Now, sometimes unconditional appropriation will simply involve taking them out of inventory, wrapping them up and saying to the buyer, there you are. Sometimes it will involve taking them out of inventory, wrapping them up, weighing them in order to determine price, and then saying to the buyer, that will be 15 euros. Or sometimes it will involve the seller marking on the container, on the packaging of these goods, the person to whom these 5 crates of fish are being allocated to. So when you were sending via a carrier 20 cases of fish, some to be dropped off in each of 4 locations, it's no good saying, can you drop 5 off at that location and 4 more at that location? They have to be unconditionally appropriated. That means it has to say on the packaging that these are the 5 which are to be delivered to the first location. These are the 4 that should be delivered to the second location. So only when the goods have been unconditionally appropriated to the contract and the buyer has notice of that fact does the risk of ownership pass. And of course, with the passing of risk, so too does the responsibility of insurance, because if the risk is transferred from me to you, then yours is the risk in terms of loss or damage. So you are the person that should be insuring these goods from the moment I tell you that the goods have been unconditionally appropriated and you have now got notice of that fact. Anyway, let's get back here to the notes. 3 possible situations. Contracts involving carriage, contracts for goods sold whilst in transit, and contracts not involving carriage. Now, the contracts involving carriage, I've dealt here with specific goods, but keep your mind open with reference to this problem or this issue of unascertained goods. If a contract specifies the date, the time, the place of the passing of risk, then that's when risk will pass. But normally, otherwise, risk passes with ownership. So we need to consider at what point in the process of this contract does ownership pass. If there's no term with reference to the passing of risk, time, place, or event, if there is no term within the contract, risk passes when these goods, remember, involving carriage, when these goods are placed into the hands of the carrier or the first carrier if there is more than one. Because once I have given them to the carrier, presumably they have therefore unconditionally appropriated because they are specific goods. Once that has happened, then the risk is yours, and you are then responsible for any loss or damage. Of course, there is an exception, which we'll come to in a moment. Goods sold whilst the goods are in transit, while the goods are in transit. It's potentially the case that I put these goods into the hands of a carrier in order for the carrier to take them to some central distribution point, which is mine. So I'm taking them from the manufacturing plant, putting them into the hands of a carrier, for the carrier to take them to some large warehouse over which I have control, and they will be unloaded, disgorged into this large warehouse, ready for further dispatch. However, it may be that in the process of transportation from manufacturing plant to distribution point, it may be that you phone me up and say, do you have 20 flat back wardrobes? And I say, well, yes, as a matter of fact, I do. They're actually on the way to my distribution point. But I can get them diverted. I can sell these to you whilst they are in transit. And that being the case, when I just make it a little bit more clear, put into the hands of a carrier, for example, to deliver to a distribution center of the seller, and those goods are sold whilst in transit on the way to my distribution center, then risk will pass to you at the time the contract is entered into. Why? Because they are in the hands of a carrier, the first or only carrier. And so you assume responsibility from the time the contract is entered into, not from the time when I give them to the carrier, because I did that 3 days ago and they're still on the way, but from the time that you and I enter into the contract. That's when you assume the risk, and that's when you assume ownership. Exceptionally, if I knew at the time the contract was entered into that the goods were damaged or had been lost, then it will be my responsibility, it's not yours. If I knew that these were damaged goods on the way, or that they had been damaged and they're being taken onwards by the carrier to my central distribution point, I know that they're damaged. Now we enter the contract, but if they're damaged before the contract is entered into, I remain liable. It's my responsibility. Contracts not involving carriage. Risk passes from the time the goods are put at the disposal of the buyer. This is not involving carriage. This is at my premises. And you ring me up, or you email me, or you telex me, and you say, do you have 20 flatback wardrobes? Yes, I do. But no contract, no carriage is involved. So when I say, yes, I do, and I have already put your name on, they are now unconditionally appropriated, they don't involve carriage. When are you going to send your driver around to collect them? And this is the situation. It's up to you, because once you come and collect them, then your goods risk passes with ownership. So the risk passes from the time the goods are put at the disposal of the buyer, and I have told you that they are now at your disposal. Finally, when the goods don't conform to required standards and it's not discovered until after risk has passed, then in that situation, it's me that's liable. Breach of warranty, breach of concerning non-conformity. We move on to preservation. There's a concept here, principle involved here. The preservation of the goods shall be preserved. And basically, they shall be preserved by the person who is in possession. Now, the carrier clearly will have responsibility for looking after them while they are in the carrier's possession. If they're mine, if they're in my premises and this is goods not involving carriage and I'm waiting for you to come around, it's up to me to preserve them. I can't put them out into the yard at the back of my manufacturing plant and let them get rained on and damaged and potentially even stolen. I have to preserve those goods. If they're on the way to you, and they arrive on the Sunday and you're not open, which you should be, but they arrive on the Sunday and you're not open, then again it's the carrier or me, one or the other, that has to preserve those goods. You should have been open to accept those goods. If the goods are being delivered and you have changed your mind and you don't want to accept delivery, it's still your responsibility. It's yours. Both parties have a duty to preserve So whoever has possession, even though ownership has passed to the buyer, if it's still in the seller's possession, it's my responsibility to preserve those goods. So here we are. You refuse to accept delivery. It's still my obligation to preserve those goods. When your buyer is obliged to pay but then fails to do so, it's the seller who has the responsibility to preserve them. But you've refused to pay. You've given me notification of breach. So although it's my responsibility to preserve the goods, it's not also my responsibility to deliver because you've rejected them. When you intend to reject them, but neither seller nor agent is available, it's your responsibility. I've delivered, I've left them, the carrier's disappeared, so he's no longer my agent. I'm not available. You look at the goods, you decided you're going to reject them, but you must still preserve them. You can't simply leave them outside the mercy of the weather. It's your job. So preservation of goods is essentially, basically, it's the responsibility of the party that is in possession of those goods. Latter point even applies unless it will be unreasonably expensive or inconvenient. Unreasonably, you can store them not only in your own premises, but you could store them in the premises of some third party, some local warehouse that has the space available. They will charge you, but you have the responsibility. And if it's not too inconvenient or too expensive, and of course if it's expensive in your preservation, you can claim reasonable expenses. I would have to pay you for the preservation of those goods. If goods are perishable, if I deliver 3 tons of tomatoes and you're rejecting them for whatever reason, but you're rejecting them, these are perishable. If I'm not available and my carrier has already left, then these are perishable goods. And over a period, not a particularly long period, but over a period, these goods will perish and become totally worthless. So you have the right, or equally the seller has the right. If you've rejected them and they're still in my possession, I have the right to sell them for whatever money I can get in order to mitigate my loss. And then I will claim from you the loss, or you will claim from me the loss. If it's you that has taken delivery, you look at them, you're rejecting them, rather than wait for me to come back for them, you can sell them locally and then account to me for the proceeds of sale. It may be that if you've rejected them for no good reason, then not only would you pay me for the proceeds that you received, but I would then sue you for breach of contract and claim the difference between our original contract price and the proceeds that you have just managed to achieve from sale. And then finally, we'll just look at impediment. An impediment is something which impedes, it's something which gets in the way. Normally, something beyond our control that gets in the way, maybe a change of law, or maybe an act of war, maybe weather, maybe the weather has been so bad that the roads have been swept away and there's no other alternative route for me to take to get to deliver the goods to you. So if it's an impediment beyond my control, or beyond your control, or beyond the carrier's control, if it's an impediment, we need to consider what is the legal position, what is the position according to the United Nations Convention on Contracts for the International Sale of Goods. If a party fails to perform, the normal position is that the other party may avoid the contract and claim damages. But if my failure to perform is due to circumstances beyond my control, if I am impeded, if an impediment has now affected my ability to perform my part of the contract, then I can claim that. If the breaching party can prove their failure to perform is due to an impediment beyond my control, then I won't be liable to pay damages. You can sue if you want, but it wasn't my fault. I couldn't do it. I tried, but I couldn't do it. The impediment should be such that it was not reasonably foreseeable. An earthquake destroys the roads on the way from my distribution point to the place of delivery where you want them. If that's the case, or Somali pirates take the ship hostage if it's carriage by sea, and so on the way to deliver the goods to you, some pirates seize the ship, and that surely is an impediment beyond my control, and presumably not foreseeable. Once the impeding event ceases to prevent performance, the contract goes ahead as normal, so long as they weren't perishable goods, because obviously you don't want some tomatoes which are 4 years old. Third party's failure to perform. If a third party's failure to perform is the cause of contract failure, so if the local government has failed to repair the road that was damaged 3 weeks ago, and that is now the cause of my breach because I can't get through to you because the local government has not been repairing the road, then we have a different situation. I will only be exempt from liability if I can show that not only me, but also the local government was impeded by matters beyond either my or the local government's control. And if it wasn't an impediment that the local government was suffering, then I remain liable. But I would likely recover from the local government. And finally, if failure to perform is because of an impediment, the impeded party must give notice to the innocent party, to the other party, within a reasonable time after first finding out about the impediment. The carrier rings me and says, I can't get through, the road is down. Well, is there no alternative route? No, there isn't. Okay, I'll contact you. I'll give you a ring and say, listen, my carrier has just phoned me up. He said the road is down between you and the local town. He can't get through. Is there anything else you want me to try? Because I can't get through to you until that road is mended, or until the snow is cleared, or until peace has broken out. So I will tell you within a reasonable time of first hearing about the impediment. And I'm going to ask, and I know you're going to respond, but what is a reasonable time in these circumstances? Well, you know the answer to that. A reasonable time in these circumstances is a time that is reasonable in these circumstances. Okay, that's the passing of risk, it's the dealing with the impediment, and it's also the duty to preserve the goods.